Good afternoon, Catherine. I am head of the HR service area at Pay Entry, and I want to welcome you to our webinar today, which is a refresher course on mandated leaves under the Families First Coronavirus Response Act, FFCRA. This law was effective March the 18th of this year. A lot has happened since March, if like me, a whole lifetime has. Um, this law contains several areas that impact employers. And we're going to talk today about two new paid leave programs that are in existence the remainder of 2020, are the emergency paid sick leave and the emergency family medical leave. We're also talk about the tax credits that you can get for paying that leave. And also, I'm going to touch a little bit on the unemployment situation here and how it's been impacted by this new Emergency Unemployment Insurance Stabilization and Access Act of 2020. Throughout the webinar, if you have questions, you can write into the chat. Today, I believe it's set up correctly so that everyone can ask questions. Just type into the chat area. I will be sending you a copy of the presentation in PDF format immediately following today's session. Okay. First of all, under this new law, employers are responsible for providing emergency paid sick leave, emergency family and medical leave, and that is paid also. The emergency paid sick leave allows employer to offer 2 weeks of sick leave available immediately to all employees for reasons related to the coronavirus. Full-time employees will get 80 hours, which is 2 weeks. Each of these are 2 weeks. And the part-time employees would also get a week, but it would be based on the number of hours that they typically worked over that 2-week period, over a 2-week period. You're allowed to go back and do a 6-month average if you feel that would give you a more accurate reflection of the number of hours that a part-time person worked. I am links in these notes, and will take you to the latest Department of Labor question and answer session or section on our website to answer some of the questions that maybe I answered today and that I don't. So when you get a reference point forward to get additional information. Obviously, you can always call me, but if you want to have some light reading in the evening, this will to tears, so you could read this instead of reading the dictionary. So the emergent paid sick leave, the reasons that qualify for sick leave include self-quarantine, employee, the fact that they have the coronavirus, or number two, they could be obtaining a diagnosis or care for exposure or symptoms. So if someone is exposed to someone who has tested positive for COVID, then this would be a sick leave plan that they would be under. Assisting, the employee could be assisting an individual who is self-quarantined because of COVID-19, and obviously that does include their being exposed to the individual and the virus, or caring for a child under the age of 18 whose school or place of care has been closed or is not available due to the virus. All in different parts of the country, so I think that the at-home orders have changed, and restrictions to businesses have changed in different ways in different areas. So you need to apply this against what's actually happening in your community. Under the emergency paid sick leave, an employee is entitled to their full regular rate of pay for up to 2 weeks if their leave is for their own virus or illness. If they're caring for a family member, however, who has the virus, or if their childcare or school is closed due to the virus, pay is two-thirds of the regular rate of pay up to 2 weeks. And that is, when we say regular rate of, we mean as defined by the Fair Labor Standards Act, which means that it does include overtime. So if someone generally gets overtime, it would include that in their regular rate of pay. If you have questions about the FLSA um, regular rate of pay, please reach out to me. So what if you already provide sick leave? Then this new leave is in addition to what you have at your company now. You can't change your existing policies to avoid what you've already obligated yourself to do. So you can't do it with your sick leave policy or reduce it just because of this new law. And employers can't require that employees use their other paid time before they use their new emergency paid leave. This comes first. You must, under the law, post a public notice informing your employees of their rights to emergency paid sick leave. If you're virtual right now, that means that they should get this posting electronically. The Department of Labor has provided a model notice, and it can be found at this website. Right now, I am going to click on this to just show you what this looks like. And let's just move it over here first. Okay, it is page post. It's available online. So you can go and by clicking on the website that I've given you here. That will pay sick leave. Now let's take a look at the paid family and medical leave. This leave is available when an employee can't work if the child's because the child's school, daycare, other place of care is closed due to the pandemic. I've gotten some questions from clients recently about, well, do we still pay for schools being closed when schools normally would be closed? No, the only if school is closed because of COVID-19. So for summer months, you would not be paying employees for time to take care of the kids unless they actually were sick. So school closings ended probably at the end of June-ish or May. So I don't have kids. I don't know when schools would end, but whenever school would have closed, that's when the COVID-19 rules don't apply to those individuals. This emergency family medical leave is a temporary extension of the FMLA rules. It adds 12 weeks of both job protected and paid leave in a public emergency. Unlike the ALA, it is paid, FLA is paid, but jobs are still protected. That means is that you hire them back after their leave is over. So the first 10 of this leave would be unpaid, and normally that's where you would see the pay sick pay for the first 10 days. Employees can use benefits offered, and then there's other forms of accrued paid leave that they have backed with you. So at the first 2 weeks, employers have to pay workers at least two-thirds of their regular rate of pay. And remember, that does include average overtime. So if this benefit does allow paid leave, it is reduced over the sick portion of the paid leave for the ones talked about, but it is still two-thirds for childcare. This is not a medical leave. It is a leave to take care of children who are out of school because of COVID-19. To be eligible for the benefit, the employee only has to work for 30 days. Under FMLA, the year, number of hours, and so there's a lot more restrictions FMLA. The definition of a child includes a biological, adopted, foster child, stepchild, legal ward, or a child of a person standing in co-parentis. The age limit is 18, and those who are 18 years of age or older who are not capable of self-care can be included under the definition of a child. But an employee who requires leave to care for a child that's over the age of 14, their school is closed, has to certify that special circumstances exist requiring care of that individual or that child in order for the employer to claim a tax credit. So if the child is 16, 17, 18, or even 15, um, there need to be special circumstances that require that person that the be there or the employee there instead of at work. Healthcare workers and emergency responders can be exempted from rules. So the FFCRA paid leave programs may not apply to your organization if you are in healthcare or if you're an emergency responder of some sort. The Department of Labor can exempt small businesses if fewer than 50 employees. The business itself will be in financial jeopardy. And employers with fewer than 25 employees don't have to comply with the job protection asked this bill. So if you have less than 25 employees, you do not have to hold the person's job, give them a job when you come back. One of the things I questioned today was how do you get exemption to small business? Well, you don't think of the Department of Labor, and they're very clear about that. An official office company has to decide that this will create a hardship for the company and have to document their reasons and maintain on file should they be challenged by the department member. For example, someone that works there filed a court case or lawsuit against the company because they weren't off the paid leave, then the Department of Labor would look at that documentation that the official had put together and they would make a determination on whether or not the company was exempt. So in the past, we thought it would be an action that you would fill out and get sent to the Department of Labor and you get a response. That's the case. It is something that you get a response to after someone has a charge against you. So the last thing behind this paid leave is that there are refundable payroll tax credits that are available to employers who provide this sick leave or emergency FMLA leave through 2020. There's paid emergency sick leave, first of all, and that's for employees that leave to quarantine themselves or stay at home or for their own diagnosis or treatment. So if they have the virus themselves or they're quarantined because of a stay-at-home order. Tax credit for these individuals is 100% of their wages up to $511 a day. For employees that take leave to care for a family member or the child's school or daycare is closed, the tax credit is $100 of wages up to $200 per day. Paid emergent FMLA leave, the tax credit is 100% of wages $200 a day. There is a maximum of $10,000 per employee, and it's over a 12-week period. I thought I'd include today the tax codes that you're supposed to use in your payroll if you are deciding to use the sick leave, or the child or the leave. I'm sorry, the FMLA type leave. You use CRA sick, and those codes are created in your system. It would be one of the things offered on the drop down as an earning code. The employees taking the leave would be paid their regular rate up to $511 a day and a maximum of $5,110 for 80 hours. Now, if the person makes more than $511 a day, they would be paid their full pay because remember, for the CRA sick, it's 100% of pay for the 10 days. Our system will can differentiate between the 511 and the total pay. And I believe we'll make that adjustment for you. And I'm going to check with somebody on that because I may be speaking out of turn. But the next earning code is CRA Care, and this is where it is still under the paid sick leave, but the employer taking leave being paid at 2/3 the regular rate of pay, up to $200 a day, with a maximum of $2,000 for 80 hours. This is to take care, to take care of a child who is out of school or daycare because of the coronavirus closures or stay-at-home orders. And CR Child VE is used if you're using the after 2-week CRA Care. You begin putting them into a category of employees taking leave paid at 2/3 of their regular rate, up to $2,200 a day, and a $10,000 maximum because it is a 10-week period of time. This all does not have to be taken at one time. It can be taken Any of it can be taken over a period of time, not consecutive days. So it is something that needs to be tracked in your system. These codes will allow you to track those. Let's talk a little bit about unemployment. This Stabilization Act came out and added additional funding to the states for unemployment resources. But to see that additional funding, states must use their eligibility and access to unemployment compensation by waiving the work search requirements. So someone who does not have to look for a job. They waive waiting period, which is normally a week or so. And they're not holding you as employer chargeable for those claims. The other thing I might add is another bill is coming and pays everyone who is on overtime on unemployment an additional $600 a week, and that comes under a separate area in employment, but it is for everyone. It's not prorated based on their hours worked or past employment. It is a flat $600 a week. And so I know from talking to a lot of clients that is keeping some of your people from wanting to come back because they're making more employment and they are for you, which is unfortunate. No one saw beforehand. Now that this runs out on July 31st, but there is strong conversation about continuing it through the end of the year. So we'll have to wait and see. No one has done it yet. I would say it is going to pass, so it's something we should be expecting. Many states have on board with this. I would say the majority of the states have. You can check out your state's unemployment website to see if they have responded or are responding to this in a positive way. Some states, there are a few that are holding out and are complete with this. But for general purposes, the entire United States has this regimen of rules that they follow. or undoing some of the restrictions for unemployment. Subcontractors, independent contractors, people who are self-employed can now file for unemployment also. So if you know someone that is an independent contractor and never paid unemployment taxes, or someone that's worked for you, they are allowed to file. They don't file against an employer's account, but they are allowed to file and receive unemployment compensation. So if you're a small business owner and you consider yourself self-employed, you file for unemployment. So what should you do at this time? Well, right now, employers should be very familiar with current laws. Make sure you are compliant, that you're following these rules, because the webinar that I did yesterday was on litigation that's triggered during the COVID pandemic. One of the things that's drawing attention is that employees are aware that there are laws about paid leave, their employers not paying them, and so they're going taking them to court over it. Sure that you are compliant in the area, and take advantage of the tax credits. They're there to offset the payment of that leave and or time away from work to take kids. So take advantage of it, and monitor the changes in interpretations. We try to keep you up to speed. We don't want to inundate you with emails, which some already think we do. But if you have any questions about changes in interpretations, I try to keep things up to date and would respond to your questions in a timely manner, and also try to do webinars that keep you posted. So just keep add to our email and we will keep you up to date. If you have any questions about your current situation, you can put them in the chat now if you'd like. One question, would if we use the CRA sick, would this be deducted from unpaid time? No, it would not. The CRA sick is for the paid sick leave program. Your paid time would stand alone and it would offset what they already had in their balance, because you're not allowed to make them use the sick leave before you up the required sick leave or the mandated sick leave. So they get to use that first. There is a recording, asking their recording for this webinar, and it will be available to you at a later time. I would like, if you could let me know, shoot me an email after if my sound cuts in and out, because I'm told that this might be a problem with this particular location. Okay, any other questions? Okay, if you have questions after, just send me an email. You can send it to HR Services. Well, oh, we had another slide there, but we don't. But you can send it to me at cgram@payentry.com, or you can send it to HR Services@payentry.com. Thanks for attending today, and have a great afternoon.